All right. Good afternoon. Welcome to Chandu biology classes. So this is a session on general studies paper 1, that is general studies paper, that is coming to JL DL classes. Fine. So we have started the discussion on Indian polity. Till now we have completed what? Constituent Assembly, sources of the Indian Constitution, parts and schedules of the Indian Constitution, and then what did we cover? We started with fundamental rights. We have already run 2 parts. Fundamental rights introduction. In the first class we did Article 12 and Article 13. That is, I told fundamental rights are contained in Part 3 of the Indian Constitution. That is contained in Article 12 to 35. In 12 to 35 we learnt, in the first class we learnt 12, 13 and also Article 14 and 18 and also 19 and 20. Okay. In the previous class we started with Article 19 and we studied up to 30. Correct? No? We studied up to 30. So in the previous class I told you fundamental rights in the beginning of the Constitution. Whenever I say beginning of the Constitution, it is 26 January 1950. It is at that time we were having 7 fundamental rights. At present we are having 6 fundamental rights, because right to property is removed from the fundamental rights. How it was removed? I told you, to remove anything from the Constitution or to add or to delete or to modify, we need constituent what? Not assembly. Assembly is required, but as of now we need parliament, we need amendment. We need what? Amendment to the Constitution. Correct? So like that, if we talk about this one, this was done through which amendment? 44th Amendment of 1978. 44th Amendment of 1978 spoke about what? 44th Amendment of 1978. In that amendment, this 7th fundamental right, that is right to property, was removed and just made a legal right or constitutional right. It was put under Article 300A. Okay. Now it is just a normal right, not a fundamental right. It is not a fundamental right. Which one? Which one? Right to property. Okay. Till now we have only, as of now we have only 6 fundamental rights. Okay. Out of the 6 fundamental rights, if we revise one more time again, right to equality, right to freedom, okay, right against exploitation, right to freedom of religion, then cultural and educational rights, these mainly regarding minorities, then right to constitutional remedies. Okay, right to constitutional remedies. So these are the things, okay, we did. Okay. So when it comes to the previous 2 classes, we did right to equality, right to freedom, right to against right against exploitation. Okay. First is right to equality, right. Second is right to freedom, not a right against exploitation. Second comes right to freedom. Next is right against exploitation. Next is right to freedom of religion. Next, cultural and educational rights, and last one is right to constitutional remedies. And fundamental rights are called as what? Magna Carta of the Indian Constitution. If they ask which of the following is the Magna Carta of the Indian Constitution, the answer is fundamental rights. And the heart and soul of the Indian Constitution is Article 32, that is right to constitutional remedies. Who said this? Dr. B.R. Ambedkar. Okay, such type of questions will come in the examination. Now, okay, in the previous class we did right to freedom of religion and also cultural and educational rights. Okay, after that I told right to property is removed. Okay, now when I talk about, if I revise again Article 19, 20 and all these things, Article 19 speaks about what? It speaks about freedom of speech and expression, that is we speak and we express. Okay, then we assemble. After assembling we form association. Okay, after forming association what do? We do movement. Okay, we move and we do residence. We can't keep moving every time. At some place we will go and stop. Okay, at some place we will go and stop. After that we will do some occupation. Okay, next thing is we have Article 20. It is talking about protection in terms of conviction. Okay, conviction is different, arrest is different. Arrest is first they will come and take me. Conviction is they will give the punishment. During the punishment also there should be some kind of protection. What is that protection? That means if I am arrested today, for me the punishment should be given as per today's law, not the law which will be made in future for the crime which I made. And for single punishment there should be, single crime there should be single punishment. Correct? No, for single crime there should be single punishment, not double punishment. And also I cannot be a witness in my own case. Even if I say I have done the crime, the judge cannot give judgment like just like that. He should have, or he or she should have proper evidence. Okay, proper evidence, then only the judgment can be passed. Next, what did we do? Next is Article 21. Okay, that is no self-incrimination, I told you. Okay, next is, what did I tell before that? Single crime, single punishment, that is nothing but no double jeopardy. That is what I told you. Okay, then I told no self-incrimination. Then Article 21 talks about right to life. Under that, even right to privacy was also included. Right to privacy, very important case is Aadhaar case. Aadhaar case versus Union of India, or you can remember that K.S. Puttaswamy judgment. Okay, K.S. Puttaswamy judgment. Okay, please remember, because in the last year I think he passed away. It's important to remember the person also. Okay, next coming to this one, Article 21, even right to digital access. Right to digital access is also a fundamental right. Okay, but every fundamental right has reasonable restrictions. Okay, suppose you people have right to digital access, that you are carrying your phones, you can watch the class whenever you want, that is there. For the NEET students, we cannot allow. If such a person, if any student is using the class, he cannot say that I have a fundamental right. Okay, we will not allow them, because we have certain rules that is applicable as per the reasons and also situations. Your people who have done bachelors and masters, you know how to use the device. Those people, they are still in intermediate, we have to have their focus in the class. Of course, you know how to use for your benefit, but during the class nobody will use, but those are the students, they may use. So we cannot allow them to use the phones. That is why right to digital access, this also has reasonable restrictions. Okay, please remember this. Next, right to clean environment, right to health, and also Article 45 is a directive principle of state policy. Under Article 45 it is talking about education. Education from 0 to 6 years and 6 to 14 years. Okay, this was made a split. 0 to 6 years was contained in only DPSP. Now 6 to 14 years was removed and put in fundamental rights. That was made Article 21A, that is nothing but right to education. Okay, that is nothing but right to education. Next, Article 23 and 24, right against exploitation we spoke. When it comes to right against exploitation, we spoke about two articles, Article 23 and 24. 23 is human trafficking, bigger thing. It is talking about every human, be it a child, or it may be a man or a woman, whoever it is. Human trafficking is prohibited. Okay, forced labor, that is also prohibited. Forced labor, I also told, it is beggar. Another thing is, it is talking about what? It is talking about child labor. Article 24, it is talking about child labor, that is up to 14 years of age. Okay, up to 14 years of age, you should not be allowing them to work. Okay, in which kind of places? Factories, mines, and also what it is? Hazardous job. But after the school, if they are helping the parents, be it in agriculture or any other things, okay, proper work, it is totally fine. Okay, it is totally fine. Okay, that is accepted. Next, we spoke about right to freedom of religion, Article 25 to 28. Under that, first thing is, you have the freedom to profess, practice and propagate any religion of your choice. Okay, any religion of your choice. That is what I told you. I told you that secularism was what? Secularism was put forward through 42nd Amendment Act, that is the amendment in the preamble of the Constitution. Preamble is amended only once. Okay, amended only once in 42nd Amendment 1976. Clear? So preamble is amended only once. In that, three words were added, that is socialist, secular and integrity. Okay, socialist, secular and integrity was added. Correct? No, in that secular, that is very much related to right to freedom of religion. That is secularism, it is explained in these articles. Okay, so 26, what is it talking about? Right to manage religious affairs. Religious affairs means, that is, I have the right to attend the temple when I want. I have the right to attend the mosque when I want. I have the right to attend the church when I want. Nobody can come and force me. Okay, that is the meaning of religious affairs. Next, when it comes to Article 27, it is talking about no one can force me to pay the tax for religious promotion. Like this you understand, no need to buy hard the article as it is, just understand. For religious promotion, nobody can come and force me to pay the tax or money. So for example, like I gave the example of Ganesha Chaturthi, something like that. Just because they want to keep the Ganesha, nobody can come and force us. Out of devotion, out of our religious sentiments, we may give. That is different. But nobody can come and force us. Why? That is a fundamental right. Nobody can come and force us. Okay. Next, what did we talk about? Okay. Freedom from attending religious instructions in state-funded institutions. State-funded educational institution. State means what? Now you should know. State means government. Funding means, it may be funding means the giving money. In private colleges also, apart from government, if the state funding is there, be it in the form of money or in the form of faculty support, that is the meaning of state funded. In such institutions, suppose some puja is going on or some church Bible ceremony is going on, something like that. That time nobody can force any student, be that student be religion of Christianity itself or Hinduism or Muslim. Okay, respectively whatever the religious affairs that is going on in the institution, nobody can force any person to attend. Okay, although I am from Islam, any Islamic activity, religious activity is going on in that institution, nobody can force me to attend in state funded institution. Similarly coming to Hinduism, similarly coming to Christians. Okay, I am talking about all religions. That is the meaning of Article 28. Article 29, it is talking about cultural and educational rights of the minorities. It protects the interests of the minorities. Article 29. Okay, which kind of interest? Cultural and educational interest. Okay, next Article 30, we spoke about what? That is rights of the minority to establish, set up and establish and manage educational institutions. Okay, that is religious educational institutions. The minorities can set up. For example, Christians have Christian missionaries. Okay, what about Muslims? They have madrasas. What about Hindus? For example, TTD runs their own schools. Okay, where they teach only Vedas and all these things. Correct? No. So they have their right, that is cultural and educational rights. So 29 and 30 it is talking mainly about minority rights. 31 it is right to property, that is removed. 32 it is talking about right to constitutional remedies. Okay, so these are the things we have already discussed. Now I want to discuss in detail, in elaborate discussion we should have now about constitutional remedies. But before that, as you can see, so those who are watching online, so TGPSC PGT course, that is starting from, new batch is starting from 1st August for Biosciences paper 3 and General Studies paper 1. Okay, so General Studies paper 1 will be covering all the static portions like polity, history, geography and also current affairs and also Telangana specific topics also. Okay, Telangana history, geography, polity, okay, society, Telangana schemes and reasoning and English, all these things will also be covered, and for more details you can contact on this number. Same when it comes to JL and DL, we are offering not just botany and zoology, that is core paper this time, even the general studies paper we are offering, and you can contact on this number. New batch is starting from 1st August. New batch is starting from 1st August, so you can enroll for this batch. Okay, so you can visit the branch for more details, that is Narayanguda, Hyderabad. That is this branch itself. So let us resume our discussion on fundamental rights. Now we have to discuss about right to constitutional remedies. An introduction to this was already given in the previous class, but let us start from the beginning. Right to constitutional remedies. Remedies means it is nothing but giving a solution. Suppose there is a problem. What is a problem? That my fundamental right is violated. For that, a solution is there in the constitution itself. A solution for my problem is there in the constitution itself. Solution means remedy. Okay, it is present in the constitution, so it is called constitutional remedy. Why I need a remedy? Because there is some problem. What is that problem? That is violation of my fundamental rights. That is what? Violation of my fundamental rights. So we have what? Right to constitutional remedies. It is contained under Article 32. Right to constitutional remedies, it is contained under Article 32. So right to move Supreme Court. That means under this you can go to the Supreme Court, or you can go to the High Court, or you can go to any other court as decided by the Parliament. But please keep this in mind. In exam they will ask so many courts, your answer should be Supreme Court and High Court. That much is enough for you. Okay, suppose you want to go to Supreme Court, under which article? Article 32. Okay, under Article 32 you will go to Supreme Court. Under Article 226 you will go to High Court. Okay, you will go to what? High Court. Article 32 Supreme Court, Article 226 you go to High Court. Got it? So this is very important to remember these articles. That is the right to constitutional remedies. Clear? Now Parliament can empower any other court to issue writs. In general you can go to Supreme Court or High Court, but some circumstances Parliament can also empower some other court. Some other court means maybe a district court or a sessions court also to issue the writ. Okay, that is also possible. But in general, okay, exception is to forget. In general, you have to remember Supreme Court and High Court. That's enough. Clear? Now, first of all, what do you mean by writ? You should know. Writ means it is a written legal document. Legal document means it is having some effect of the judiciary. Okay, legal document. Okay, so under Article 32, Supreme Court will issue, like I told you, under Article 226, High Court will issue for what? For violation of fundamental rights. For what? For violation of fundamental rights, not for constitutional rights, not for legal rights, not for human rights. Please keep this in mind. Only fundamental rights. But High Court can also issue writs under Article 226 even for legal rights also. Okay, that I will tell you when I talk about High Court's topic. No, don't worry. As of fundamental rights, Supreme Court and High Court will issue. Clear? That much you remember. Now, as you can see, fundamental rights is guaranteed under Part 3 of the Indian Constitution. Okay, so this is the Constitution. If you think under Part 3, it is guaranteed. Okay, now if they ask who is the guarantor of the fundamental rights, the question is, who is the guarantor of the fundamental rights? The answer is Supreme Court. Who is guarantor of fundamental rights? The answer is Supreme Court. Okay, Supreme Court. There is another question that comes in the examination, that is who is the defender of the Constitution, or who is the defender of the fundamental rights? They can ask anyway. Who is the defender of the Constitution? Who is the defender of the fundamental rights? If they ask, the answer is President. In that you will have options like Parliament, President, Supreme Court, none of this, or also you can have Prime Minister. Like these options, all are very important personalities, very important officers. You will get confused. The answer is President, because while taking the oath, okay, oath and affirmations is which schedule? Which schedule? That is third schedule. Correct? No, TRs of old PM. TRs, T if you take T-A, not the T which you drink, A, and that A stands for what? A stands for affirmations, oath and affirmations. Okay, that oath and affirmations, every government office or every minister or every constitutional post has to take the oath before conducting their duty. Oath means what? I will take the oath that I will conduct the duty in a faithful and most proper way. That is the meaning of it. Okay, different offices have different oath, but only the President takes the oath to defend the Constitution, not anyone. Even the Prime Minister does not take the oath to defend the Constitution. But in general, each and every one of us have the fundamental duty to defend our Constitution. Okay, but the oath is taken by only whom? The first citizen of India, that is the President. Only he takes the oath as the defender of the Constitution. Only he takes the oath to defend the Constitution. So if they ask who is the defender, or who is the defender of Constitution or fundamental rights, the answer is what? President. The answer is what? President. Okay, now come back to fundamental rights. Forget about President. Okay, now is as a guarantor of fundamental rights. Okay, if my fundamental rights is violated, like you can see, then the Supreme Court will issue writs. Even High Court can also issue writ. So what do you mean by writ? This is nothing but a legal document. Okay, legal document. But this concept of writ is borrowed from Britain. I told you while discussing about Government of India Act 1935, there is something called prerogative writs. I told you these prerogative writs, just remember like this, but I will explain you when I come to fundamental rights. I told you prerogative writs are nothing but just writs itself. Oh, that is one of the type of writs. No need to worry about that. Okay, so Government of India Act 1935, that contains writs that was borrowed from Government of India Act 1935. But Government of India Act 1935 was put forward by whom? The British itself. That's why in general we say it, writs we borrowed from Britain. Okay, writs, if they say in the option, if they say Britain and also Government of India Act, answer is Government of India Act. But if they don't mention Government of India Act, if they give only Britain, the answer is Britain. Okay, writs is borrowed from Britain. Clear? I hope it is clear to all of you. So let us proceed now. Let us see what are the type of writs that is issued. But what is the procedure before the court or anyone issues writs? We have to approach the court, right? My fundamental right is violated, then I have to go to the court. So what is that actual procedure? Let us see. So if I talk about writ, suppose my fundamental right is violated. Okay, then I will directly go to the Supreme Court or High Court. Okay, that means if I have gotten any disease, I will go to the hospital or doctor. That means I am the sick person. Here the person whose right is violated, if that person only goes, such a person is called aggrieved person. That person is called as what? Aggrieved. Aggrieved means who has been affected. Aggrieved means in general, aggrieved means who have been affected. Okay, suppose you have come to the class, but I ask you to stay out of the class. That means you are the person who was affected by losing the class. That means you are the aggrieved person. Correct? No, that is the meaning of it. Aggrieved person directly goes to the Supreme Court. Another type is instead of aggrieved person, instead of him complaining, okay, some other person who is sitting in the class will tell why are you not allowing him. That means such a person is called as public spirited person. Public spirited person. Okay, instead of the actual person. Okay, suppose you are affected. Instead of you, he will appeal to me that why are you not allowing ma'am to the class. Then you are called as what? Public spirited person. On behalf of someone you are representing. Okay, you are asking for the writ. That is public spirited person. If you are asking for one person, or you may ask for so many persons. Suppose all these ma'ams, I will ask them to stay out of the class. On behalf of them, you are asking the thing, means they are called public spirited person. You may ask in favor of one person or many persons. It does not matter for us. Okay. So you may be a single person who is asking, or you may be an organization, some other organization, or you may be an NGO. NGO means non-governmental organization. Okay, something like that. It may be not be a government organization only, it may be non-governmental organization also can ask. Clear? Sometimes instead of these people, okay, a group of people will come and approach the Supreme Court or High Court. All of you go and approach the Supreme Court and High Court. That such a thing is called representative petition. That means you all are representing some other entity and you are approaching the Supreme Court or High Court. That is meaning of representative petition. That is the meaning of what? Representative petition. Okay. Also, if this group of people are represented by a single entity, okay, it's not about fundamental rights. This extra information I am giving, they can ask in the examination. Suppose it is called as class action suit. Class action suit means, see, this group of people are represented by some other person because all are affected by something. That is the meaning of class action suit. Okay, suit, that is not suit. That we go, let us go to Abhilash, we will buy suit, not this, not the suit I am talking about. Suit means I am telling about suing. Suing means you are filing a case against someone. So on behalf of these people you are filing a case. That is the meaning of class action suit. That means actually there was a class action suit. If I give an example, okay, Nestle is the company that prepares Maggi. There was a class action suit against whom? Nestle. Why? Because in the Maggi they found that there is a element or a metal that is called manganese. Okay, so that is what? It is a toxic element that was found out. So they told that it should be stopped, manufacture of Maggi, but later it was found or not found or made up or whatever it is, later it was found that it is not there. Okay, so later it was squashed, that judgment or whatever that case was dropped and Maggi came to be used again. Clear? So that is one of the example of class action suit. Okay, all of us as being represented there. Okay, although we didn't know that we will go to the court or something, okay, we didn't know that somebody is representing us, but all of us are consuming that, correct? No, that is the meaning of class action suit. Got it? This is about what do you mean by writ, how to approach the court and all. Now let us see what actually is the writ. What are the type of writs that we have? There are 5 types of writs. Okay, they will ask question from this part. They will ask question from this part, definitely one question will come. Definitely out of these 5 writs, one of the writs will come in the examination, maybe more than one writs also. What are the types of writs? So one is habeas corpus. Okay, habeas corpus, you may have heard about it in movies also. This is habeas corpus. Next is we are having mandamus. Next is quo warranto. Next is what? Quo warranto. Okay, next is certiorari. Okay, certiorari. This is what? Certiorari. Okay, next is we have prohibition. Okay, next is prohibition. Okay, so these are the 5 types of writs you have to remember. Okay, once you understand the meaning, remembering this becomes easy. So let us discuss each one of them one by one. So first is what we have? Habeas corpus. Okay, habeas corpus is the very important writ that we have. So anyways, I will share the document with you. So you can, I already shared, I think, fundamental rights. So first of all, habeas corpus. Okay, habeas corpus. What is the meaning of habeas corpus? Habeas corpus means to have the body of the person. Habeas corpus means to have the body of. Body of means here they are not talking about, usually we refer body when person is dead, correct? No, here it is not actually the dead body they are referring to. The person who has been arrested, that person's body. That means that person should be presented before the court or the magistrate. Okay, that person should be presented before the court or the magistrate. That means if you arrest someone, within 24 hours you should be present them with them before the magistrate within 24 hours. Okay, to avoid this kind of things, what they will do, you must have seen in the movies, they will arrest on Friday evening, because Saturday and Sunday will be holiday. Okay, so that they don't have to produce before the magistrate 2 days, they will get the time. So they have to produce on Monday. So these things you have seen in the movies, correct? No. So that is the meaning of habeas corpus. Habeas corpus means compulsorily within 24 hours you have to produce on normal days. You have to produce before the magistrate or before the court. Okay, that is the meaning of to have the body of. When this is issued, suppose a person is arrested. Okay, a person is arrested. This can be issued. This writ can be issued against public authority and also private individual. Okay, this can be issued against public authority and also private individual. Public authority means what? It is nothing but government or state or nothing but in general we call it as police. Correct? No, any person who is representing the government. Or private individual means what? Any normal person apart from the government. That means you kidnap that person. Kidnapping. Okay, that is the meaning of this private individual. Okay, without their will, if you are taking someone anywhere, okay, that is nothing but that draws the writ of habeas corpus. That time the court can issue habeas corpus. Okay, they will say that you are this kind of you are the person, you have taken this such a person A, within these many hours you have to produce them before the court. Like this they will issue the writ, that is the court will issue. So against private individual also, against public authority also. This you have to remember, habeas corpus, public authority also, against private individual also. So what will happen is, I think it is there here. Okay, so suppose let us take example public authority is there, or let us take example public, instead of public authority let us take police only. Police has arrested someone. Okay, police has arrested someone. Now what will happen is the court will say that produce the body of that person, that means bring that person in front of me, court or the magistrate. So he has to produce, who? The police has to produce this person. This person will come here in front of the court. In front of the court he will come. Okay, now police will say, now the court will ask why you have arrested him. Now police will give the reason why he has arrested that person. Okay, if the reason is valid, then okay, you arrest him, no problem. If the reason is valid, you arrest him, let us put him for further enquiry, that is fine. Otherwise, what will happen is, if the reason given by him is not valid, if the reason given by this person is not valid, then this person will be set free. Who? The person who is detained. The person who is arrested will be set free, and for this person what they will give? They will give some punishment, and also this person will also be given compensation. This person will also be given compensation, that is money. Understood? Suppose the reason for arresting the person, if it is correct, what will happen? No problem. Even if they issue it, the person will produce him before the court and he will say, this is the reason we have arrested. But if the reason is not correct as per the court, as per the, who will decide if this is correct or not? The court will decide or the magistrate will decide. Then what will happen? Then they will give punishment, or they will give what? Some action will be taken against such a kind of officer, and for this person who was detained, for him compensation will be given. So that is the meaning of habeas corpus, to produce the body. Why you have to produce the body? To know whether what you have arrested is correct or not. This is applicable in all cases. Is applicable in all cases. With some cases there are exceptions. Suppose arresting a terrorist, that time you may need so much enquiry that you may not be able to produce. Okay, that some exceptions are also there. Okay, so this is about habeas corpus. Understood? To have the body of the person. Clear? So that is the meaning of it. The word habeas corpus means to have the body of. Okay. Now next thing is mandamus. Next thing is mandamus. Okay, mandamus means we command. Mandamus means we command. That is, mandamus means we command. That means suppose I am a person here, that is I have to teach for you general studies. Instead of teaching general studies, okay, I will sit and simply talk with you. I will sit and simply waste your time and talk with you. Okay, that time what you have, you people have the right to ask why you are not taking the class. You people will come and take the class, because this is the time for our class. You have to take the class. That is the meaning of what? You are commanding on me. Okay, that is the meaning of you are asking me to do what? You are asking me to do the duty correctly. Correct? No? You are asking me to do the duty correctly. That is what I am supposed to do, you are asking me to do. Why? Because I am not doing, or even if I am doing, I may not be doing it correctly. Suppose I am not teaching correctly, what you will do? You will go and complain. Correct? No? Or you may tell, you are not teaching right thing, you are teaching it in a wrong way. That is the meaning of what? You are commanding because you are the right. Correct? No? So that is the meaning of mandamus. That is the meaning of what? Mandamus. Clear? The mandamus means asking a person to do his duty correctly. Which kind of person you can ask? You can ask a person that is the government official. You can ask only the government official. Okay? This mandamus can be issued against the government official. But in private institution also, you can ask, like what I to give the example, current example. But majorly this is issued against, see, it is issued by the court to direct a public authority to perform the legal duties obliged under the law to do, which it has failed to perform or refused to perform. Under this comes central or state government, public officials, okay, public corporations, inferior courts. It cannot be issued against any private individual, President of India, state government and Chief Justice of High Court, whatever. Understand this? Understood this anyone? No, most of you didn't understand, I know. See, understand one thing. When I told about my example, as per the institutional rules, you can issue. That is, you will ask, sir will say. That is not what? That is not mandamus. That is an example of mandamus. But you will not go to the court. Correct? No. Sir has the power to direct me, or you have the power to direct me, command me to do the class. Correct? No. That is the meaning of mandamus in general terms. But in reality, this can be issued only against government. Okay, against government, not against any private office. Okay, suppose you go to any courier office, you ask them to send your parcel to somewhere. Suppose they have not sent it, okay, you cannot go to the court. You can call the customer care and you can complain. That is a different thing. Or you can go to consumer court, that is a different thing. But this is not under fundamental right. This is not under this mandamus. What we are talking about, it is about only government officials. But this mandamus cannot be issued against certain kind of persons. That is, one is private individual. That is, the people who are not government. This cannot be issued against private people. Okay, this cannot be issued against private people, and it can also cannot be issued against whom? President. It cannot be issued against whom? President. Most important, president. If it cannot be issued against president, automatically it cannot be issued against the governor also. It cannot be issued against the governor. Okay, it cannot be issued against whom? It cannot be issued against the Chief Justice of India and Chief Justice of any High Court. Okay, see, they are very high constitutional posts. Okay, you cannot ask a president to do his duty correctly. You are electing a person who is very qualified, who are qualified in the sense qualified to do the duty in the office. Not I am not talking about educational qualifications. Okay, you can't ask a governor to do his duty. You cannot question a governor. You cannot question a Chief Justice of India. You cannot question a Chief Justice of High Court. But can you issue what mandamus against Prime Minister? Yes. Yes, it is totally possible. Why? Because Prime Minister is a person who is elected by us. That is, he is an elected representative. Correct? No. Although we are not electing the Prime Minister, we are electing the party, their party. That is, from that party, one person will be made the Prime Minister. For example, our Prime Minister is from Varanasi constituency. Correct? No. He is also elected by the people. So he is also an elected representative. That is, we people are electing. That means we have the right to command. Okay. So the court has the right to issue mandamus to the Prime Minister also. If it is Prime Minister, definitely you can issue to Chief Minister or any other ministers. Got it? So this is about mandamus. So suppose this person, example, if you take this person has got seat in some medical college, that is government medical college, or any private medical college also. If it is a government seat, that time this person goes to, for example, take government medical college. He goes to this college, but they refuse admission. Okay, he has got a proper merit, under merit he has got the seat, but they refuse admission. That time what will happen? He will go to approach the court, then this court will issue the writ of mandamus to this government. You have to give the seat. Okay, this is the meaning of what? Do your duty correctly. That means whether you are not doing the duty or doing the duty incorrectly, that time mandamus will be issued. Clear? Any confusion? Okay, it is only talking about duty. You are issuing only again government officials, but except President, Governor and Chief Justice of High Court. That's all about mandamus. So let us go to next writ, that is quo warranto. Okay, quo warranto. By what authority or by what warrant? Okay, by what authority or by what warrant? That is, suppose, okay, by what warrant? First of all, when you come to join the course here, correct? No, when you come to join the course here, first of all, you would have done a research, you would have gone through YouTube, or you would have researched about our institute, and you would have researched about who is teaching and all these things, correct? Then you would have seen if there is Sir's qualification, everything you would have seen, based on that you would have come, correct? So suppose some random person comes instead of Sir, that time first of all you want to know who is teaching you, correct? No, then you will have the right to know by what authority or by what warrant you are eligible to teach life sciences for us. Suppose I come and teach life sciences, first of all you will ask my qualification. Suppose suddenly Sir doesn't come tomorrow, I come and take 9:30, instead of taking aptitude paper or general studies paper, I start teaching zoology or botany. That time you will ask what is your qualification. That is the meaning of by what authority or by what warrant. That is, you have the right to issue quo warranto. Okay, this is also issued against only public authority. This is also issued against only public authority. You people ask, I have every right to say, I am not qualified, but I know how to teach botany or zoology. That time you have no option. Either you can stay or you can go, because this is private. But if it is a government office, you have every right to ask, because this is also issued against what? Public authority. So quo warranto means it says it is issued by the court against a person who holds a public office unlawfully. Unlawfully means me teaching you life science, it is not ethical. It is not ethical. First of all, it is not unlawful, because this is a private organization. Suppose this is a government organization, it will be first unlawful and it is not ethical also. Got it? So holds a public office unlawfully. If such a person administrates any public office unlawfully, then the court can issue writ of quo warranto against that person and can remove that person from his position. So this is the meaning of the writ cannot be issued against any private office. That is the meaning I said, you cannot issue, go to the court and ask the court to issue quo warranto on us, because we are private. Okay, but anyways, you know that who is qualified, they are only teaching you, correct? No. So when it comes to here, when it comes to quo warranto, understand one thing. Suppose you go to any government medical college, something, okay, you go for some, for example, you go for a cardiologist, okay, instead of a proper qualified surgeon or qualified doctor treating you, if a compounder is treating you, what you will do? No, first of all you will not even take the treatment. Okay, first you will complain why he is taking. That time what they will do, the government will make sure that he is removed or some action will be taken, correct? No, that is the meaning of public office or public authority. Same thing when it comes to any other public office, okay, any other public office. Suppose you go to GHMC to get some document, there a person who is not qualified is sitting and doing the work. That time also you can complain, okay, that time also you can complain. Suppose you go to some mandal office or tahsildar office or something, a work that has to be done by the tahsildar or some other person, tahsildar or someone, it is being done by a peon, okay, he is signing, okay, that is completely unlawful, that is crime also, correct? No, that time you can approach the court. So that is the meaning of asking why, by what authority you are telling, by what authority you are telling, correct? No, this is the meaning of it. Suppose I am here, for example, you take, I am here in this institute, Sir is here. Suppose we say the institute will close today at 3 o'clock, you please, all of you have to leave, that means you will leave. But some random person whom you have not seen till now comes and tells you, you have to leave by 3 o'clock today, all of you. That time you will say, who are you to tell? That is the meaning of by what authority you are telling us. Understood? The previous thing is do the work correctly, command us. This is who are you to tell? Simple words. Who are you to tell us? That is the meaning of quo warranto. Got it? Who are you to tell us? That is the meaning of quo warranto. Clear? Mandamus means do your duty, or if you are not doing the duty, that is mandamus. This is quo warranto is who are you to tell us? That is a simple meaning you have to keep in mind. Quo warranto means by what authority. Okay, got it? So next let us move to next very important writs. These are very much important. First is certiorari, that is to be certified. Next we have prohibition. Here you have to pay more focus, because there is chances that you will get confused, because both are similar, both are very similar. Okay, certiorari and prohibition both are very similar. Okay, You want AC. Remote you want? Okay, all right. So next thing is we are having certiorari and prohibition. So when I talk about certiorari, okay, when I talk about certiorari, it is issued by the Supreme Court and the High Court to the lower courts. Okay, it is issued by the Supreme Court and the Higher Court. Okay, so certiorari and prohibition, it is happening between, not between us, it is happening between the courts themselves. It is happening between the courts themselves. So we have, if I talk about structure of Indian judiciary, we have lower courts, that is we have district court or session courts. Okay, let me not write session court, you will get confused. Okay, on top of this we have High Court, we have Supreme Court. So this certiorari can be issued by Supreme Court to district court or High Court to district court or something like that. Okay, or between higher courts, these are called higher courts. Higher court, I am not talking about High Court. Higher court means Supreme Court and High Court. These two courts are called higher courts. They are called, these two are lower judiciary. Okay, these two are higher judiciary, these remaining are lower judiciary. Issued by higher judiciary to lower judiciary. What? Certiorari and also prohibition. Okay, these two writs are issued by higher courts to lower courts. Why they are issued? That is, one thing is it is issued by courts, the matter to it to proper further processing. Can also issued by Supreme Court and High Court for quashing the order by passed by the lower court. It happens when the lower court acts beyond the limits of its power and makes, okay, I will explain in simple terms. So much words are given. See, understand one thing. Suppose here there is Ram and Shyam, two persons. Okay, they are fighting, they are having a case about a land issue. So much cases in India, if you go and see, it is about land disputes only. Okay, lot of cases in India are about land disputes only, be it normal person or be it any public representative, that is being any minister or anything, okay, be it chief minister or whoever, not about this state I am talking about, one of the states, chief minister, recently there was a land issue case. Okay, so if you talk about their cases, most of the cases it is about denotification, such kind of cases only you will see, it is about land issue only. So here this piece of land, they have a dispute, they are having a case. So what this person will do, this land is belonging to district A, this land is belonging to district A, this land is belonging to district A. That means the jurisdiction of this land is under which court? Court that is present in district A, correct? No, court that is present in district A will have the jurisdiction. Jurisdiction means the effective control. Okay, suppose you both have a dispute over the land that is present here. That means what? You should come to the court that is me, that is court that is present in this class. You cannot go to the next class because your jurisdiction, that is this land is present in this class, that means jurisdiction is here. Suppose instead of this person Shyam goes to district B and this district B processes the case and gives judgment, what will happen? That time this higher court, that is Supreme Court or High Court, will say for this district B, this is not under your jurisdiction. First of all, it is not under your jurisdiction, so you cannot pass any judgment. Okay, already judgment is passed. That time what it will do? It will just transfer the case from here to here, or it will transfer the case from here to itself. Okay, from district B to district A, or it may cancel the case from here and it can transfer it to himself, that is Supreme Court itself. Okay, first thing is it may say the case will be transferred from district B to district A. Another thing is it can also cancel the judgment that is there. It can also cancel the judgment that is passed by district B. Okay, cancel the judgment that is passed by the district B. So certiorari is after the judgment. One thing you have to understand, this is after the judgment, this is issued after the judgment. Okay, certiorari, you have to understand one thing, after district B has passed the case, after district B has passed the judgment, that time what it will do, Supreme Court, it will say you pass the case to district A or it will pass the case to itself, Supreme Court. Then it will, what it will do, it will cancel the judgment that is given by district B, because it has what, exceeded its jurisdiction. Jurisdiction is only up till district B, but the case is belonging to land A, belongs to district A. So that can only pass the judgment, that can only pass the what, proceeding and all, then only it can pass the judgment, but this is not having any power. Okay, so that is not proper. So it will, after the judgment only the Supreme Court can issue this. After the judgment only the Supreme Court will issue this certiorari. Okay, after the judgment only if it comes to know, then it is called certiorari. Same thing I will explain prohibition here itself. If it is okay, otherwise you will get confused. See here, prohibition, let us go through the wordings that is given. Prohibition means to stop. There it is not stopping, already judgment is given. Judgment is given. After judgment is given, okay, after judgment is given, what Ram will do? Ram will go to Supreme Court. Ram will go to Supreme Court. Supreme Court will issue the judgment. Supreme Court will not issue the judgment. Supreme Court, what it will say here in certiorari, Sham will get the case. Sham will win the case. But Ram says he will go to the Supreme Courts because the judgment was given by District B, but the land belongs to District A. That is, after the judgment, the Supreme Court will issue what? Certiorari, because this person will go only after the judgment. Why? He has lost the case. Because he does not know that the case itself cannot be taken by District B, but it has taken it. In most cases it happens. Okay, they go beyond their limits. Okay, that time what will happen is, this judgment will be cancelled by the Supreme Court and the case will be transferred to District A, or it will take it to itself. That is the meaning of it. That is after the judgment. He is thinking that even in District B I will win the case. After losing, then he will go to something. So that is the meaning of certiorari. But here it is before the judgment. 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 See here. So it is to stop. That is, it is issued by the Supreme Court and High Court to the lower courts to start the proceeding of any case. That is, the difference between writ of certiorari and prohibition is the stage at which they are issued. Okay, certiorari is issued after the case is heard and decided, whereas the writ of issued while the proceeding is happening. See, understand one thing, certiorari after the judgment is given, but prohibition even in between the case. Okay, still judgment is not given, or even before the case is taken up. Even before the case is taken up, but proceedings are coming up. Okay, the case is being heard today, first hearing. You can see in news or even movies, first hearing, second hearing, there will be so many hearings. Even before the first hearing itself, they can stop this. Okay, or even in between, there it is after the judgment. There it is after the judgment, certiorari. But here it is completely stopping the judgment itself. Okay, forget about the judgment. Proceedings also they will not allow. Even if it is allowed, in between also they will take it up. No, you are going outside your jurisdiction. You are not supposed to take the case. So send it to me. Send it to me means send it to Supreme Court or High Court, or send it to directly to District A. That is the meaning of prohibition. Understood? So suppose person A and person B, they are having dispute over land on land A. Judgment is passed means that time what you issue? Certiorari. Before the judgment is passed, between only, or even before the proceeding is taken, that time if you pass the case to actually District A, that is called prohibition. That is you are stopping. You are stopping it. Certiorari means after the judgment, everything is done. That time it is called certiorari. In between it is called stopping means prohibition. The word itself says prohibition. Prohibit means to stop. I told prohibition of untouchability, Article 17. 17 means prohibit means to stop untouchability. So here the word prohibition means to stop. Okay. So we are discussed 5 writs. First is mandamus. First is habeas corpus. That is to produce the body. Okay. It is issued against public authority also, private also. Okay, but coming to mandamus, it is to do your duty correctly. That you can say only to public official, but you cannot say to the President, Chief Justice of India, Governor, Chief Justice of High Court. Okay, because they are very high constitutional posts. To Prime Minister, can you say yes? To private individual, no. You cannot say to private individual. You cannot ask me to do my duty correctly. The court cannot say. Next is what? Quo warranto. Okay, who are you to do it? Okay, who are you to tell us? Who are you to tell us to go at 3 o'clock? Correct, no ma'am? So that is the meaning of, if some random person comes and tells you, what you will say? Who are you to tell us? That is the meaning of quo warranto means by what authority? By what authority? That can be issued against only public official. Okay, that can be issued against only public official. See, all the writs against public official only. But when it comes to habeas corpus, even public and also private. Okay, next comes certiorari and also prohibition. Okay, if the case is already decided and judgment is passed, then you ask it to pass, that is called certiorari. In between, if you ask it, or even before the proceeding, that is to stop, that is prohibition. Clear? Got it? That's it. That is about the right to constitutional remedies. That is Article 32. Article 32, it is heart and soul of the Indian Constitution. Without this, you cannot say that fundamental rights are justifiable. Justifiable means, that is if there is violation, You can go to the Supreme Court or High Court, that can be present. What kind of writ should be issued? What are the solutions that we have for fundamental rights is given under Article 32. That is why it is called as what? Heart and soul of the Indian Constitution. It is the Constitution, this is the article that has enabled us to live properly. Because of this only our rights we are able to enjoy, because of this article. The state or the government, the fears which article in the Indian Constitution? If we say Article 32, because it is all about us. We have been given the rights under Article 32, because under this the courts can issue writs against the government also. Got it? That is the meaning of Article 32. That is right to constitution and remedies, and when it comes to writs, is borrowed from Britain. Okay. Now let us see 3 more articles when it comes to fundamental rights. Okay. 3 more articles when it comes to fundamental rights. They are not included in any category. Okay. Article 12 and 13 are also not included in any category. We have 6 categories, like I told you. 7th category, right to property, is removed. Article 12 is talking about what is a state. Anything that represents government is a state. Article 13 is talking about judicial review. Okay. Similarly, 33, 34, 35, it is talking about fundamental rights, some exceptional cases. Okay. What are they? Let us see. Just a minute, where did it go? I think I missed it somewhere. Let me have a look at the slide. Just a minute. Let me have a look at the slide. So, Article 33, 34 and 35 we have to discuss. Just a minute. So, now let us see the Article 33. Okay. It is not given in the slide. I will give it, modify and give it to you. So, let us see Article 33. Article 33. (34), 35. Article 33, 34 and 35. So, Article 33 says that all these fundamental rights that we have, correct, no? All these fundamental rights that we have, they are restricted to certain group of individuals or certain category of people. Okay. So, when it comes to police or armed forces, be it military, navy, air force or paramilitary force, okay. Okay, when it comes to various border security force, all these forces, you can say all the security forces, for them these fundamental rights, okay, are, I will tell it in a very simple way, are restricted to security forces, I can say security personnel or security forces. Security forces, under this you can include police also, CAPF people, CRPF means Central Reserve Police Force, like that, okay, Central Armed Police Force, and it can be armed forces, various things, and various paramilitary forces. These are the paramilitary forces, and you can also include border security forces. All these people, these fundamental rights, they cannot say that they will enjoy complete fundamental rights. certain fundamental rights, they are restricted for them. What they are, you need not know. Okay, they cannot say that they want to enjoy fundamental rights all the time. Okay, suppose some meeting is happening. Okay, some meeting is happening, with some enemy country, we want to launch an attack. That time the army people, they sit and do the strategy. Okay, they sit and do the strategy, be it National Intelligence Agency or okay, NSA, National Security Advisor, or someone else. Okay, Defense Minister, Home Minister, they will sit and do the strategy, or Army Chief, something like that, or also we have Chief of Defence Staff, that is also we have. Okay, who is Chief of Defence Staff? You have to find out and comment today. Okay, who is Chief of Defence Staff? Okay, Chief of Defence Staff, not the Defence Minister. I am asking about, see, what you told Defence Minister, that is perfectly correct. Okay, there is one important authority that is created. It's good you tried, not a problem. NSA advisor is Ajit Doval, that is different. I am asking about Chief of Defence Staff. What do we have? We have Army, we have Navy, we have Air Force. Okay, they feel they are superior in their own wings, but we want coordination among all the three. So for that, we created one important post that is called Chief of Defence Staff. Okay, the first person that was created was, his name was Bipin Rawat. Okay, unfortunately, in helicopter accident, okay, it got crashed. Okay, near Ooty it got crashed few years back, recently only, and he passed away in that. He was Bipin Rawat, and recently another person, second person was appointed. That you have to comment, don't tell me now, you have to put it in the comment section. Previous class I asked question, that also did not put in the comment section, you have to do it. Okay, you have to do it, that's all. Okay, so who is the Chief of Defence Staff? You have to put it. Next thing is, you have to understand, so like I told you, some meeting is happening. So some very important confidential information, some very intel related information, you got an intel that there will be an attack. Okay, so you are also putting some strategy to capture those terrorists or something. That time you cannot say that I have freedom of speech and expression. You cannot someone say, you cannot come and post on Facebook or Instagram or say, no, we are in this one, we are planning to do an attack like this. Then you cannot say that. That time what will be done to you? You will be punished. That time you cannot go to the court. I have fundamental right of freedom of speech and expression. That's why I put it on Instagram. That you cannot say. Okay, court will say you are unfit to be in the armed forces or something. That is the meaning of certain fundamental rights are confined, or I can say restricted to security personnel. That is under Article 33. That is also a fundamental right. That is also present in Article 33. Okay, certain fundamental rights are restricted. Who will restrict this? The Parliament. Okay, who will restrict this? The Parliament. Okay, they are restricted to certain army personnel. Okay, certain army personnel or security personnel, even for police. Okay, suppose CBI investigation is happening, something is happening. Okay, if you say in public, we are going to raid here, then what is the purpose of raiding there? Okay, already you are giving an information. Correct? No, that is not proper. You cannot say I have Article 19, and you cannot say I have various other articles, something like that. Got it? Okay, suppose someone is coming to attack us. That time the duty of the army personnel is to defend us. Definitely they will do it, and they are doing it. That time you cannot hide and let them attack you and say that I have right to life. Okay, that is not possible. I am giving example that they definitely won't do. Okay, next thing is Article 34. Okay, Article 34, here also there is restriction of fundamental rights. Okay, in areas where martial law is in operation. Okay, so Article 34 is talking about restriction of fundamental rights again. Article 33 is talking about, Article 33 is talking about restriction of fundamental rights to certain category of people, that is security personnel. Okay, restriction of fundamental rights in Article 34 is talking in some areas where fundamental rights are restricted. What are those areas? That are the areas where martial law is in operation. You have to know what is martial law. Okay, what is martial law means? It is nothing but military rule. It is nothing but military rule. Okay. Yeah. So for example, when normal government is not able to control the administration, is not able to control the protest of people. Okay, that time the complete government machinery has failed. That time the military will come and take over. Okay, okay. That for example, in Manipur you would have seen. Okay, in Manipur there was lot of violence. It is still happening, and you can see in earlier there were places of Jammu and Kashmir and all. There also in some areas martial law is applied. Even in some areas of northeast India, martial law is applied. That means the military rule will be there. In that areas, fundamental rights, certain fundamental rights are restricted. Okay, you cannot move here and there at whatever time you want. They can stop you and ask why you are moving, then they can check you. Okay, but here if you move, okay, in normal time, nobody can come and stop why you are moving anywhere. Nobody can come and ask you. Okay, but in those areas where martial law is in operation, fundamental rights are not. They are not like, we are not telling that you will not be given fundamental rights. Fundamental rights are there, but they are restricted. That means they are highly restricted. Okay, so martial law means where military rule is there, where military rule is there. Okay, in such areas where military rule is there, you don't have a CM or governor or anything. Okay, military people will come, the Indian government will authorize the Indian army to come and take control of that area until peace is restored. That is the meaning of military rule. Okay, Article 33 is talking about restriction of fundamental rights to certain group of people. Article 34 to certain areas where martial law is in operation. Martial law means it is military rule. Okay, martial law means you have to understand it is what? It is nothing but military rule. Got it? This is the meaning of it. Military rule is in operation. Okay, Article 34 is talking like that. Now Article 35. To give effect to any of the fundamental rights, who has the right to frame the law? Like I told you, Article 17, it talks about prohibition of untouchability. To give an effect to that fundamental right, the Parliament passed what? The Parliament passed Civil Rights Act or Prohibition of Untouchability Act, or also it is called as Civil Rights Act of 1955. Okay, like that various acts are being passed by the Parliament to give effect to fundamental rights. Okay, so I am talking about Parliament. Did I say anywhere state legislature? No. So whenever we talk about fundamental rights, with respect to fundamental rights, Right to Education Act was passed by whom? The Parliament. So with respect to fundamental rights, who has the power to make laws? It is only the Parliament and only Parliament. Not any state government, not any state legislature can make any law with respect to fundamental rights. With respect to fundamental rights, be it you are a citizen of India or you are a foreigner staying in India, with respect to you, the fundamental rights, the law is made only by the Parliament. Be you be a person of Telangana or Andhra or Telangana or Uttar Pradesh or wherever, your fundamental rights is decided by the Parliament, not by your state. Okay, not by your state government, I mean. Okay, so any law with respect to fundamental rights are being made only by the Parliament. So if you study in book, this article will be given in a very different way, you will not understand, but I have written in a simple way. Parliament's power to make law to give effect to fundamental rights. Only Parliament has the power, not any state government, not any state legislature. Clear? That is the meaning of Article 35. 33, restriction of fundamental rights to certain group of people, that is security personnel. Okay. Next is 34, in which area? Where martial law is in operation. Okay. Next is Article 34. Okay. That is 35 when it comes to fundamental rights. Okay, when I talk about martial law, you can also consider one more thing, that there is something called AFSPA. AFSPA means Armed Forces Special Powers Act. For example, even in Nagaland and Jammu and Kashmir, AFSPA is being operation. Okay, that is kind of military rule that is being operated. This AFSPA can be enacted by Parliament and can also be removed. Okay, that is, this AFSPA is kind of a military rule itself. That can be done by whom? Parliament. It can make that law in some areas and again it can remove that law. Okay, that is the power with only Parliament that has the power. Okay, so that is the meaning of this. Only Parliament has the power to make law to give effect to fundamental rights. AFSPA is also a kind of military rule. This is, I'll write it, Armed Forces Special Powers Act. Okay. This is also a kind of military rule. It is there in Nagaland, so many northeast states, even in Jammu and Kashmir and all. Okay, Armed Forces Special Powers Act. Okay, got it? This is the meaning of it. So We have covered all the fundamental rights. Now, I told you these fundamental rights are not just available only for the citizens, even for the foreigners. So, but certain fundamental rights are available only for Indians, not for foreigners. That means we have to know what are those fundamental rights that are not available for foreigners. So, let us see that. You can have a look at it. Okay, you can have a look at it. So, if you can see what are the articles that are available to them, what are the articles that are available to foreigners, that is fundamental rights that are available to foreigners. So, first of all, fundamental rights are not absolute, they come with reasonable restrictions. All these things we learn. That is, what are the restrictions, like public order, morality, all these things I told you, health and all these things. Now, when it comes to this one, suspension during emergency. Suspension during emergency, all rights except Article 20 and 21 can be suspended during national emergency. Okay. Now, but there is one thing, that is Article 19. If national emergency, see national emergency, when I talk about emergency provisions, I will discuss this again. Now, I am explaining in a brief way, understand this. National emergency, if it is issued, there are two reasons to issue. One is external aggression, that is, if there is external war, some outsider is coming for war with us, any other country, that is called external reason. Okay, external reason. Another one is internal reason. For example, national emergency is applied in some part of India because of some Naxalite attack. Naxalites are within India. That is what? Internal reason. Okay. So, internal reason, national emergency can be due to any of these two reasons. If it is due to external reason, that time only Article 20 and 20 will be available. All other things will be scrapped. You will not be given. It will be suspended. But if it is due to internal reason, what happens is 20 and 21 will be available, correct? No, I told you 21 and 20 will be available during any kind of emergency. But along with this, even Article 19 will also be available. Even Article 19 will also be available. If national emergency is due to external reasons, only and 20 and 21 will be available. If it is due to internal reason, 20 and 20 along with that Article 19 will also be available. Clear? Is it clear? So, no need to get confused. If I say national emergency, you have to remember except 20 and 21 everything will be removed. This is one exception that you do not have to worry about it now. When I talk about emergency provisions, when I talk about national emergency, state emergency and financial emergency, then I will get back to it again. Okay. At that time I will tell you one fundamental rights I have already discussed, let us explain in detail now. Now, if I talk about emergency, only Article 20 and 21 will be there, remaining everything will be removed. Okay. Next thing is available only to citizens is rights under Article 15, 16, 19, 29 and 30. That means these are not available to foreigners. That is 15, 16, 19, 29 and 30. 15 is what? Discrimination. This is available only to citizens. That is prohibition of discrimination. That means what? You can discriminate between Indians and foreigners. Correct? No? When it comes to any place, you can discriminate between Indians and foreigners. That kind of discrimination is allowed. That means what? Available only to citizens, Article 15. Article 16 is talking about public employment, there also prohibition of discrimination. But when it comes to between Indian and foreigner, you can discriminate. You can give priority to Indian in that job. That is Article 16 and 15 is available only to Indians. Article 19, freedom of speech and expression, right to move, assemble and all these things. If you allow foreigners to do whatever they want to move wherever they want, that means you are giving them lot of power. Okay, that's why Article 19 is also not available. Article 29. Article 29, if you allow foreigners to come and set up their religious institutions, what they will do? They will do conversions, forced conversions. That is why Article 29 is also not available. What is Article 30? Article 30 is about religious instructions, religious institutions. Article 29 is about protecting the interests of minorities. Minorities of our countries is fine, but when it comes to foreign people who come as minorities here, for them we have to treat them with suspicion only. Okay, Article 29 and 30 is not available to them. This much you remember. So, 15, 16, 19, 29 and 30. 15, 16, 19, 29 and 30 it is available only to citizens. Okay, but other articles are available to both. Okay, remaining you remember. Okay, remaining you not remember. First you remember which are not available. That is 15, 16, 19, 29, 30. That's it. Okay. Now we are done with this chapter, fundamental rights, very important chapter we have done. Now it will be complete only when we do some questions. Okay, I wanted to answer which part of the constitution deals with fundamental rights? Part 3. Okay. Now which article is known as the heart and soul of the constitution? Article 32, that is right to constitutional remedies. Next, right to equality is covered under which articles? 14 to 18. Abolition of untouchability is provided under which article? 15 is right prohibition of discrimination. 16 is prohibition of discrimination in public employment. This is based on religion, race, caste, sex or place of birth. This is when it comes to employment, correct? No. 17, untouchability. So this is the right answer. This is about titles. This is about talking about titles. Yeah. Next thing. Article 21, get it? Right to life and personal liberty. If I say Article 21A, it is right to education. 21 is right to life and personal liberty. Which article deals with right to education? 21A. Next thing. Which article prohibits child labor? Child labor. 24. Saying in doubt. 23 is complete human. Complete human it is talking about. 24 is talking about specific child labor. So that is 24. Freedom of speech is guaranteed under which article? Freedom of speech and expression. That is first I will say, I will express that, let us go for a trip. That is 19(1)A. Okay, 19(1)A is what I am telling you. 19(1)B is what? You will assemble. 19(1)C is what? Associate. 19(1)D is what? E is residence. F is occupation. So this is 19(1)A is freedom of speech. Freedom to practice religion? 25. Freedom to practice any religion is 25. Next, against double jeopardy, that means Article 20, specifically 22. So 20 class 1 is no ex post facto legislation. That means I should be treated as per this law, not upcoming law. That is Article 21. 20 clause 2 is, this is nothing but clause. Okay. If I write A along with that, that is subclause. This is clause 2, no double jeopardy. Clause 3 is no self incrimination. Clause 2 is double jeopardy. Got it? Next is, which article protects individuals against arbitrary and arrest and detention? I am talking about arrest.
Article 22.
Article 22 is arrest. 20 is conviction. About punishment, it is being spoken in 20. 22 is arrest. I have told you many times, Article 22 is arrest. Which article empowers the Supreme Court to issue writs? Supreme Court. I will send all of you home if you don't tell the answer.
Article 32, sir.
Article 32 will issue writs. Supreme Court. 226 is High Court.
Defender.
Okay. High Court 226. Supreme Court 32. That is what we discussed majorly today. Article 32. Okay. Next, which fundamental right is available to foreigners in India? Read peacefully. You won't be in hurry to answer. Right to vote. Right to speech. Right to property. Right to life. Right to vote, they don't have. Right to speech? No, they cannot speak. Of course they can speak. They cannot speak whatever they want. Right to property? No, they cannot come and acquire property as and when they want. Okay. Right to life, definitely it is there. Right to life is there. Okay. Which fundamental rights cannot be suspended even during emergency? 20 and 21. Which article deals with protection from arrest in certain cases?
Article 22.
22. They can ask in different way. Next, cultural and educational rights are primarily meant for which group?
Minorities.
Minorities. Okay. They are also called minority rights. 29 and 30. Next, the right to property in India is now considered as what? Legal right. Okay. Next one, which landmark case expanded the scope of Article 21? Article landmark case. That is not Menaka, that is Maneka Gandhi. Okay. It's okay. The right to constitutional remedies enables what? President to grant pardons, Parliament to amend the Constitution, enforcement of fundamental rights, citizens to demand reservations. read correctly. The right to constitutional remedies. In right to constitutional remedies, what did we study?
Citizen
What did we?
demand reserve.
What did we study? Did I speak about reservation today? When I spoke about constitutional remedies, what did I say? We spoke about writs.
Enforcement of fundamental
Rights are issued for what? Against the violation of fundamental rights. If there is violation of fundamental rights, I will go to court so that my fundamental rights are enforced. Okay. So everyone think on your own. Just because someone is answering, don't get carried out by that. Okay. Think. Okay. So the right to constitutional remedies. Okay. It is for enforcement of fundamental rights. That is, if there is no enforcement of fundamental rights, if there is violation of fundamental rights, that is corrected, that there should be proper enforcement of fundamental rights. So enforcement of fundamental, that's why I have written very close options. The answer is enforcement of fundamental rights. Clear? So focus on this question first. The right to constitutional remedies, they can say justifiability of fundamental rights or enforcement of fundamental rights. When I talk about DPSP and preamble, there is no enforcement or justifiability. When I talk about fundamental rights, it is enforcement of fundamental rights is right to constitutional remedies. Okay. Which article prohibits discrimination in public employment? 16. Correct? 16. That's it. So we are done with fundamental rights. In the next class, we will come up with new topic in polity, or we will come up with new subject itself. Okay. So I will wind up now. So please comment. What did I ask? Chief of Defence Staff, you have to comment in the comment section. Okay. I will wind up now. Thank you. Let's meet in tomorrow session. Take care.